be seated. Okay, good morning, ladies and gentlemen. I'm going to get some people into the jury box here. We're going to start with juror seat number 1. It's going to be Monique Thakpe. You're going to go to juror number 1. Oh my God. Yeah, I need to put up seat number 1.
They're from the bottom.
Seat number 2, Michelle Lee Smith. Seat number 3, Joshua Chedester. Seat number 4, Josu Cologne. Seat number 5, Kathy Stombaugh. Number 6, Amanda Darnell. And number 7, Tashara Alvarado. Okay, thank you very much. And if everyone, both in the jury box and in the gallery, can fix their attention to the screen here, we have some instructions. Ladies and gentlemen, I am Judge Kristen D. Simmons, and it is my pleasure and privilege to welcome you to the 54A District Court of Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our duties of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person who is accused of a crime and the prosecution have a right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Do we have someone who has difficulty hearing? Oh, okay. Thank you. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to serve as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on a jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. Can you all rise? Can you raise your right hand? Do you solemnly swear or affirm that you will truthfully and completely answer all the questions about your qualifications to serve as jurors in this case? If you do so, say I do.
I do.
Thank you. You can be seated. I'm not sure what's going on. It's only when you're judge. Okay. I want to introduce my court staff to you. We have Addie Nash, she is my court recorder and judicial assistant, and I have Mr. Nicholas Bigelow, who is my court officer. This is a criminal case, and it involves a charge of assault or assault and battery, which I will explain more fully later. The charge has been made against the defendant, who is named Yvonne Hartman. The defendant's attorney is Mr. Stephen Cornish. Mr. Cornish, please stand and list any witnesses you anticipate calling at this trial.
Good morning, Your Honor. Steve Cornish on behalf of the defendant. I don't intend to call any witnesses in the trial. However, as everyone knows, the client has a constitutional right if they so choose to testify.
Thank you. And the assistant prosecuting attorney in this matter is Mr. Brian Ring. Mr. Ring, please stand and list any witnesses you anticipate calling today.
My name is Brian Ring, and I intend to call Pamela Hartman.
Does anyone in the jury box or anyone waiting for their turn to get in the jury box know the defendant or any of the lawyers or the witnesses by name?
No.
No one know? If you know them, just raise your hand. Okay, sounds good. We think this trial will last for one day. That means still in today. If you believe that the length of trial will be a real hardship for you, please raise your hand. You believe it'll be a hardship for you, sir?
I gotta get kids at 3 o'clock, and my wife's been going through heart problems for the last week. She's been in and out of the hospital.
Okay, so you have a personal medical situation at home that you believe will create a real hardship for you? Any objection to him being excused?
Nothing to do. Thank you, Your Honor.
None from the defense. Thank you, Your Honor.
Thank you, sir. You may be excused. That was juror number 3. We're gonna replace Mr. Chadester. Did I say that right?
Chester.
Chadester.
Thank you very much, Your Honor.
Thank you.
Thank you.
Okay, let's see here. Thomas Foltz. Please take seat number 3. Anybody warm? Anybody need this fan on? Oh, sounds good. Okay, anyone else believe that uh, staying today for trial is going to present a real hardship for them? Oh, very good. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes them unable to sit for 2 to 3 hours at a time? Or does anyone have a sight or hearing problem?
No.
Sir,
I have a torn meniscus, so it's sometimes difficult to sit for extended periods of time.
I don't have anything torn and I can't sit for 2 to 3 hours at a time. So we're not sitting here for 2 to 3 hours at a time. We will take breaks. I usually do it at the top of the hour if it's appropriate to break due to what's going on in the courtroom. But we'll definitely have time for you to stretch and get fresh air or snacks or whatever is necessary. Anybody else have any issues? Okay. And no one having any sight or hearing problems? Can everyone hear me clearly?
Yes.
Yes.
Thank you. Okay, this is a criminal case, and the paper used to charge the defendant with the crime is called a complaint. The complaint in this case charges the defendant, Yvonne Hartman, with the crime of assault and battery. And the complaint reads as follows. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about May 21st, 2020, at 916 Call Street, located in the city of Lansing, Ingham County, state of Michigan, the defendant did allegedly commit the act of assault or assault and battery and did make an assault or assault and battery upon the following person, that being a Pamela Hartman, contrary to Michigan Compile Law 750.81. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal case or in criminal trial so the defendant and the jury can hear the charges. You must not think it is evidence of her guilt or that she must be guilty because she has been charged. Okay, person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. I will now relinquish you to the attorneys to complete their voir dire.
Thank you.
Mr. Ring.
Thank you, Your Honor. As the judge said, my name is Brian Ring. These questions today aren't intended to embarrass you. They're not intended to harass. They're just intended to, so that we get a fair jury. Somebody that's going to be fair to both me as the state and both to the defendant. I'm going to start with, has anybody ever served on a jury before? Juror number 5. Juror number 5, what was that, a civil jury or a criminal jury?
It was criminal in Heath County.
Okay, how long ago was that?
Many years, 20 or so at least.
And were you guys able to come to a verdict in that case?
We did.
And was that a overall pleasant experience for you, or did you have a negative experience?
It's pretty easy.
Was there anybody else that had served on the jury? Does anybody know anybody that works in law enforcement? What are they to you?
My stepson is a cop in Fayetteville, Carolinas.
Okay, does he talk to you about his work?
Yes.
What juror number is that?
Juror, oh, apologies, juror number 7. He talks to you about his work.
Yes,
Does he enjoy his work?
sometimes.
Do you think that because your stepson works in law enforcement, that you would believe testimony over from a law enforcement officer over somebody who's not a law enforcement officer? Does anybody else have any family or friends that work in law enforcement? Has anybody ever had any interactions with law enforcement? Speeding tickets, anything? I see hands from everybody. We'll go to you, juror number 1. What was your interaction with law enforcement?
I've had,
And was that an overall positive interaction with you or a negative?
yeah, it was positive.
We'll go with juror number 6. Have you had any interactions with law enforcement? What were those?
Just like these cases, with boyfriends.
Were you the victim in those cases? And did those cases go to trial? Did you make a police report in those? Thank you for being honest with me. Has anybody ever been convicted of an assault? Has anybody ever had a close friend or relative that was convicted of an assault? Juror number 4.
Convicted?
Yeah. No, I'm sorry. Juror number, one more time on the hands. Was that juror number 7? Juror number 7?
Family, friends.
Do you think they were treated fairly by the system?
Yes.
Juror number 3. I have to prove this case beyond a reasonable doubt. What does reasonable doubt mean to you?
It means that there's something wrong. Bring the thought, what they're doing, what could be.
So if I can't tell you that the victim was wearing a yellow shirt on that day, is that enough reasonable doubt? No. Does anybody have kids? Let's go to juror number 2. How many kids do you have?
2.
Do your kids ever tell you 2 conflicting stories? And you have to judge which one's telling you the truth and which one's not?
Yes.
What are some of the things you look for when you're trying to determine who's telling you the truth and who's not?
Which one is putting blame on the other one first?
Do you have any other tells that they have?
No.
And who else had kids? You're number 1. Same question. If you got 2, how many kids do you have?
3.
You have 3. If you got all 3 of them, they're all telling you 3 different stories. How do you know which one's telling you the truth?
Well, the other 2 are really young. One is 2, and the other one is the 8 one. My
Okay.
daughter's 9, so.
So if your 9-year-old's telling you that your how old was the youngest?
2 and 8.
So if your 9-year-old's telling you your 2-month-old did it, it's probably not right. It's probably not true. Is it? Sorry, who else? Sorry, one more time. Let's go with your number 4. How many kids do you have?
I have 4.
The same question. All 4 of your kids telling you the same story. How do you determine who's telling the truth?
So for me, it all depends on the scenario. What was done was what's being accused by my kids, and just how their reaction and how their posture.
Let's say it was cookies. One of them ate cookies. Only one of them ate the cookies. How do you determine which
Well,
one ate the
typically,
cookies?
my 2 younger boys has the evidence on their face.
Okay. That's fair.
So,
That's fair.
Just depends, I guess. If one of them comes running into the room saying, "I didn't do it," it's typically the one who did it.
Fair.
Not being accused. It just varies.
In a case of assault and battery, how many of you would like to see some type of medical report or medical evidence? See no hands. How many of you would like,
Can you repeat the question?
in a case of assault and battery, how would you like to see medical reports, medical like a medical report from a doctor or some type of injury. You like, thank you. That was juror number 4. And if you didn't have any medical reports or or any injury during a report, would you be able to convict without that?
I believe so. I mean, with photos and whatnot.
Okay, thank you. One of the elements is that they intended to do something. How do we know what somebody intends to do? Juror number 30, how do you know what somebody intends to do? Juror number 4, how do you intend? How do you know what somebody intends to do?
Just by actions leading up to.
Juror number 6, same question.
How they act, I guess. What he said.
Let's take a car accident, for example. Say when you're driving, you're struck by another car. You both pull off the side of the road and get out and talk to each other. What do you use to gauge whether or not that driver intentionally hit you?
How they act.
Do you look at what you see before the impact? Would you look at their body language?
Yep.
Everyone has sympathies and prejudice. It's part of life. I don't need to know what yours are, but I need to know whether you can judge this case based on the evidence presented and not bring in your sympathies and your bias. Can everybody judge this case on the evidence presented and not any sympathies or bias?
Yes.
That was everybody, yes. I have no further questions, Your Honor. Thank you.
Thank you, Mr. Cornish.
Thank you, Your Honor. I'm gonna stand down here so I can see everybody. Good morning. Again, my name is Attorney Steve Cornish, and I have the privilege of representing Ms. Hartman here. Ladies and gentlemen, the good news for you is that I go second on everything, pretty much always, so my stuff is much shorter. There was a couple of people that I think saw raise their hands with reasonable doubt. And I really wanted to kind of touch on that just really quickly and just talk to a few people if I could. Juror number 5, did you answer the question about reasonable doubt? And if not, could you?
I did not answer it. And what was the question?
Can you tell me what reasonable doubt means?
The evidence presented is what I'm gonna make my decision on.
So does anybody else have a different answer as to what beyond a reasonable doubt means? So let's say there are 2 witnesses. One witness says, I didn't do anything. The other witness says, I did. Or she did. Sorry. For you, what would you need to believe that beyond a reasonable doubt?
Just additional questions, answer. I guess listening to everything. You just have to put it all together to make your final decision.
Kind of like with juror number 4, we talked about the cookie crumbs on the face, right?
Sure.
So let's take the cookie example, because that's one of my favorite. Let's say none of the kids have cookies on their face. And so now you've got to make that decision as to which one of the kids you think ate the cookies. What other things could you look at other than physical evidence? I'm going to call that like a sign on the face, the chocolate on the cheek, or the crumbs on the shirt. What else could you look into?
Just basically just getting more in depth, asking questions. I mean, with this scenario, it's a little harder with kids, but just getting more in depth with the question, just kind of just seeing, paying attention to the details, their demeanor. And typically, if I can't find a reasonable doubt or who did it with a reasonable doubt, I just exclude everything, just shut it all down. And typically after that comes out.
Number 2, nobody's really kind of picked on you very much yet, so I'm going to kind of work my way back down the line. Would you agree if you don't have that sign, that physical evidence, would you agree that maybe something called credibility would come into play? So the nice lady there is going to record us. We have to say yes or she gets upset. So, all right, thank you very much. Number one, can you describe what you think credibility means?
Going back to the cookie situation, then I would say if one of the child ate one of the cookies before previously, or multiple times, then you know that other child may be convicted.
Number 7, I'm gonna jump all the way down to the other end of the line. What if one of the kids in that story tells you a version of the story, then later tells you a different version of the story, then later tells you a different version of the story? Would you agree that that person's credibility is kind of plummeting like a plane?
I would agree.
Okay. And so would that help, by show of hands, would that help everybody reach the credibility issue, which really kind of goes towards the believability of the person, which leads you to the reasonable doubt? Would everybody agree that that would lead you to the reasonable doubt? By a show of hands. All right, everybody's hand is up. All right, thank you. Does anybody have a problem with the fact that sitting here right now, Yvonne doesn't have to do anything at all? She can sit here this entire day and take notes or not take notes. She doesn't have to do anything. And right now, and throughout this entire trial, she's innocent unless the prosecutor here can prove to you beyond that standard, beyond a reasonable doubt standard. But everybody agree that that's okay. I'm seeing a lot of nodded heads and hands here. Thank you. Now, a lot of people don't know this, but in the United States, you do not have to testify ever as somebody accused of a crime. Does everybody understand that now that I've told you that?
Yes.
Okay, now the judge is going to explain stuff like to you in the rules. If I say something, it's not a rule, it's not evidence. If the prosecutor says something, it's not a rule, not evidence. But be assured one of us would yell at each other if we started telling you something that's true. And the judge will correct us if we're misstating the law to you. Okay? Everybody gets good with that?
Yes.
So, other than a guilty conscience, can juror number 3 tell me a reason why you wouldn't want to testify?
Self-incrimination.
Okay, so that's going back to the guilty conscience,
Oh,
right?
yeah.
So aside from the guilty conscience, why wouldn't you want to sit up there in that box and testify in front of a room full of people?
What? Repeat that, I'm sorry.
Is there a reason why you wouldn't want to do that?
Oh, no.
Okay. Can anybody, by a show of hands, can anybody think of a reason why you might not want to get up on that stand and testify other than a guilty conscience? Number 4.
Nerves?
Nerves is great. Nerves is actually what I was kind of looking for. How many people like getting up in front of a schoolroom full of people and talking? Anybody want to do that? Now, let me ask you this. Do you want to do that when a trained, experienced person in a courtroom, a lawyer or otherwise, is asking you bullet point question after question after question after question while you're sitting in that hot seat? That might not, maybe that's a reason why you might not want to get up there. Would everybody agree to that? And so let's go back to that credibility thing, which again, the credibility lets you judge the witness, lets you judge the reasonable doubt. What do people think? Juror number 6, what do you think if somebody's sitting up there and they're nervous and they're sweating and they're shaking a little bit while someone's asking questions? What's the first thing that pops in your head when someone's sitting there doing that?
They're scared,
They're scared.
they're worried, anxiety maybe.
Okay. Could you think if that person's scared and shaking and sweating, they must be lying, guilty.
Mhm.
So would that be a good reason why somebody might not want to take the stand? Okay. So throughout this entire trial, again, like I said, I don't really have to do anything. My client doesn't have to do anything. Can I get a show of hands that everybody agrees? If the prosecutor fails to meet all of those check boxes on the list of things called elements that he has to prove beyond a reasonable doubt, that my client would be guilty of that crime. Can I get a showing of hands that everybody agrees that they would go back and vote not guilty if he fails to do his job? It's like that. everybody, number one, she might be confused about the question.
Can I say that? Can you say that one more time?
Absolutely. So if the prosecutor doesn't do, if I don't do anything, if I just sit here this entire day, I don't have coffee, but if I was sitting here just drinking my coffee and not doing anything, but he doesn't do his job, would you agree that the way our system is set up, that you should vote not guilty if he fails to meet his burden of proof? That. Thank you. That was not journalable. Because again, the burden is entirely upon the prosecution beyond that reasonable doubt standard we talked about. Ladies and gentlemen, that's really all I have for you. Appreciate it. Thank you.
Any challenges for cause?
No, because, thank you, Your Honor.
Any for cause?
None from cause, Your Honor. Thank you.
Thank you. Any preemptory, Mr. Ring?
Your Honor, this time I feel like they can excuse juror number 6.
Okay, thank you, juror number 6. You may be excused.
Thank you.
Okay, Randy Van Spearen. You're gonna take seat number 6. Mr. Cornish, any challenges or preemptory challenges for this?
The defense would like to thank and excuse juror number 1, Your Honor. Thank you.
Thank you, juror number 1. You may be excused. And replacing juror number 1 will be Lila Luato. Thank you. You may voir dire the jurors.
Thank you. Juror number 1, I asked a lot of questions. Were you able to hear all those?
Yes, yeah,
Do you have anything in there that you think that I might need to know?
I don't think so.
So briefly, what is beyond reasonable doubt to you?
No questions left, nothing that could possibly incriminate or there's nothing, there's no questions left unanswered that are pertinent to deciding those parts of what.
The elements?
Yes. the
So there's no questions as to the elements.
Right.
Okay, so if I couldn't tell you that she had what color shirt she had on, that's irrelevant.
Right, that doesn't, yes.
Okay, thank you. And juror number 6, what is beyond a reasonable doubt to mean to you? Thank you for that. Juror number 6, have you ever been convicted of a crime?
Nope.
You ever had any involvement with law enforcement?
Speeding ticket.
How'd that go for you?
That was fine.
Thank you. Juror number 1, same thing. Involvement with law enforcement,
So no speeding tickets or anything.
friends, family, law enforcement. And juror number 6, I asked a lot of questions as well. Did you hear all those questions? Is there anything that you thought I need to be made aware of pertaining to you? Okay, thank you. Juror number 6, as a result of injury, would you like to see some type of injury in an assault and battery?
If there was injury, I'd like, try to see evidence of that.
Injury is not an element in this crime. I don't have to prove that there was or was not an injury. Is everybody, are you okay with that, juror number 6? Juror number 1, are you okay that I don't have to prove if there was an injury or was not an injury? Is that a yes or no?
Yes.
Thank you. She's recording, so
Yep,
she
sorry
can't
about
hit
that,
the
yes.
the uh-huhs and the uhs. All right, I have no further questions. Time. Thank you, Your Honor.
Thank you, Mr. Cornish.
Thank you, Your Honor. And 6. Very briefly, did either of you have a different answer to any of my questions or didn't understand or hear some of them? I'm going to indicate that was juror number 6 and 1, both agreeing. I don't have any other questions. Thank you.
Thank you. Mr. Ring, any challenges for cause?
None for cause, Your Honor. Thank you.
Mr. Cornish?
No, Your Honor, thank you.
During any preemptory
At
challenge.
this time, people would like to thank the excused juror number 4, Your Honor.
Excuse me. He was there the last time. You had an opportunity to preempt him then.
Approach judge.
Amen. Have a seat, sir. Okay, juror number 4, you can be excused. Thank you. And we're going to replace juror number 4 with Jody Van Landu. Did I say that right? Van Landit. Van Landit, thank you. Okay, Mr. Cornish,
Thank you. The defense would like to thank you, excused juror number 7.
juror number 7, you may be excused. Thank you. And replacing juror number 7 is going to be Lucas Alzalbi. Okay, you can go on there.
Thank you, Your Honor. Juror number 4, did you get a chance to hear all of my questions?
I did.
Did you have anything in those questions that stood out in your mind that you wanted to let me know about?
No,
No involvement with, any involvement with law enforcement?
no,
What is reasonable doubt?
that I had no question about anything that you brought up, that it's clear in my mind that it either was or was not.
And how do you judge the credibility of someone?
Based on the demeanor, the question, how they answer the questions, based on the situation.
Thank you. Thank you for that. Juror number 7, what does reasonable doubt mean to you?
Yes. Feeling that they're, I guess, yeah, I don't know how to describe it, other than just feeling unsure about something.
Okay, thank you. And how do you judge the credibility of somebody?
Yes. Demeanor, the way they speak. Just listening to what they say. Maybe their history.
Thank you for that. Is there any type of evidence that you would wish to see in an assault?
Not particularly.
Are you okay with the fact that I don't have to prove there was an injury? Juror number 4, are you okay with the fact that I don't have to prove there was an injury?
Yes.
Juror number 7, I asked a bunch of questions. Is there anything in that that you feel you need to let me know about?
I don't know if it makes a difference. I did some work through MSU. Trying to use all courts.
Okay. What kind of work?
And I train students to become youth advocate or student advocates for youth in the juvenile justice system. So, it's working with probation officers. Keep them out of detention.
I have no further questions. Thank you.
Thank you, Mr. Cornish.
Thank you. Is there any of my questions you couldn't hear? Juror number 4.
No.
7? Is there anything that you would answer different?
No.
7? Both of you would agree that right now, if the prosecutor stood up and said, Your Honor, we're all set. He was done for the day. What would your verdict be? If he said, like this second, sat down and said, I'm done for the day. I don't have anything else to present.
Without showing me anything,
Yes.
I would have to say she was innocent because I don't have any proof of her guilt.
And number 7.
Yep, same answer.
So if he does show some stuff, some evidence, we'll call it, and you're like, maybe the defendant did this. Do you think that's beyond a reasonable doubt? Maybe. Yeah,
Like,
maybe.
If maybe, I'd say that's, beyond reasonable doubt.
Can you help me a little bit more with beyond a reasonable doubt thing? Can you
Yeah, I
explain
guess
that a little bit better for me if you got
if, I don't know, I guess if I don't feel very sure, like the evidence and what has been presented doesn't clearly or, indicate guilt, then it's not guilty.
You would agree that maybe probably isn't going to cut it, though, right?
Yeah.
So, and again, the judge reads all the rules. I'm just going to paraphrase a little bit, but it's a fair and honest doubt growing out of the evidence or lack thereof, right? And number 4, you're nodding along as well.
Correct.
So you would agree that lack thereof could be one of the things that would prevent you from saying guilty if there was a serious lack of evidence. Would you agree?
Absolutely. Yeah.
And number 7?
Yes.
Okay. And now when you get that instruction, you'll be able to listen to it and review it and understand it as the judge gives it to you. You think you got a good grasp on that, right? Number 7?
Beyond reasonable doubt.
Yes, sir.
Yes.
Number 4?
Yeah.
No further questions. Thank you, Your Honor.
Thank you. Any challenges to pass?
None for cause. Thank you, Your Honor.
You put the pass?
No, Your Honor. Thank you.
Any preemptory?
People are satisfied with this jury, Your Honor.
The defense is satisfied, Your Honor.
Ladies and gentlemen, we have a jury. The remaining of you, we thank you for appearing today, ready and willing to serve. Oh. Don't give up too quickly. We don't know what's gonna happen tomorrow in courtroom. That side of the building, okay? You too may have your turn, but today you're off the hook. So thank you. Thank you for appearing. We're gonna release you with our deputy court administrator. The remaining of you, we're going to give you some more jury instructions before we let you go to lunch. All rise. Okay, you can be seated. Okay, ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I don't know why I was doing this. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Can you please rise? Raise your right hand. Do each of you solemnly swear or affirm that in the action now before the court, you will justly decide the question submitted to you, that unless you are discharged from the court from further deliberation, you will render a true verdict, and that you will render your verdict
only on the evidence introduced and in accordance with the instruction of the court. If you do so, say I do.
I do.
Thank you. You can have a seat. Okay, you will have a copy of a written copy of my instructions, but you won't get them until we allow you to deliberate, and you'll be able to refer to them at this time. So this court rule is not accurate. Since you cannot predict the course of a trial, these instructions may change at any time. And at the end of the trial, you'll get a copy of my final instructions that you can take with you during deliberation. Now I will explain some legal principles that you will need to know and the procedure that will follow in this trial. First, the elements of the charge. There's a definition of assault. The defendant is charged with the crime of assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a battery upon a Pamela Hartman or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. Second, that the defendant intended either to commit a battery upon Pamela Hartman or to make Pamela Hartman reasonably fear an immediate battery. An assault cannot happen by accident. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought she had the ability. As used in these directions or instructions, the word force and violence mean any use of physical force against another person as to harm or embarrass her. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about May 21st, 2020 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven out every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary doubt or possible doubt, but a doubt based upon reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. The trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence in the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what facts of the case are, or what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or influence that affect how the witness testifies? In general, does the witness have a special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in this case? When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to my court officer, and he will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, please tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to my court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them because information obtained outside the courtroom does not have these safeguards. It could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. 1, it is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about this case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. Everyone has a notepad and pen? Oh, excellent. You can see that I have chosen a jury of 7, or we have chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw lots, that means we're going to pick names, to decide which one of you will be dismissed to form a jury of 6. So one of you is going to be serving as the alternate. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instruction during the trial after all the evidence has been presented. You will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. Okay, it is just about 12:30, so I need to give you a break. We're going to break for 30 minutes. Well, we'll be back at the top of the hour, and then we'll proceed with opening statements. Remember that you are under oath to serve as jurors. You all have a juror tag. You're not to speak with anyone that is connected to this case, so you do need to be careful because you don't know who may be connected to this case. If you feel while you're away that someone has violated those rules, you'll let my court staff know immediately upon return. So I'm going to release you to lunch, and then a court will be re-adjourned at 1 o'clock.